This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Now the Honorable Chester Horn and Richard Segal will present a 1-hour elimination of bias program on getting rid of bright lines, advancing equity in the legal profession. So first, we have the Honorable Chester Horn Jr. He is an esteemed jurist who has devoted his career to public service. He served as a judge of the Los Angeles Superior Court for 21 years and presided over countless noteworthy and complex cases during his tenure. As an attorney in the California Department of Justice, he quickly established himself as a skilled attorney, gaining a reputation for his ability to navigate the intricacies of complex civil litigation in both state and federal courts, including several high-profile cases wherein he represented governmental purchasers and California consumers in multi-district treble damage class action lawsuits resulting in large multi-million-dollar settlements. In 2002, after decades of legal practice, Judge Horn was appointed to the Los Angeles Superior Court. Over the course of his career, Judge Horn has earned the respect of his colleagues and peers for his legal acumen and dedication to the law, and he has won the admiration of countless litigants for his compassionate approach, keen insights, and firm commitment to justice. Next, we have Richard Segal, a distinguished and seasoned litigator, joined ADR Services, Inc. in 2023 to help litigants efficiently and effectively resolve disputes. With his expertise in business litigation and a deep-rooted passion for conflict resolution, Mr. Segal is dedicated to fostering cooperation and helping disputing parties find common ground. As a former San Diego litigation practice leader and office managing partner at Pillsbury Winthrop Shaw Pittman, he has a history of successful trial and appellate litigation in state and federal courts, representing primarily business entities from mid-market private companies to Fortune 50 corporations in individual, multi-party, and class action cases where managed disputes ranging in value from tens of thousands to hundreds of millions of dollars. As a mediator, Mr. Segal draws upon his extensive background in litigation to assess the strengths and weaknesses of each party's position, enabling him to provide objective and insightful guidance. While in practice, Mr. Segal was a founder and for 17 years was a leader of Pillsbury's firm-wide LGBTQ+ affinity group and sat on the firm-wide diverse committee. He was also deeply involved in attorney recruiting and hiring for 27 of his 28 years at the firm, including as a member of the local and firm-wide hiring committees and as San Diego's hiring partner. So Judge Horn, Rich, passing it to you.
Thank you very much, Hayward. Welcome, everybody. On behalf of Judge Horn and myself, I'd like to welcome you to this presentation. What we're going to be talking about today is an aspect of the issue of elimination of bias that doesn't necessarily go into try and figure out why bias is there in the first place. You heard some of that earlier today in the implicit bias presentation that our colleagues offered up this morning. But we're more about basically talking about how you can recognize where it fits into the overall operation of your firms or employers, and how you can manage that so that you can actually achieve the diversity goals that you have and to have a more representative employment group in your business or your firm. So what we talk about this as our main theme is getting rid of bright lines. Now, the agenda for this presentation is we're going to start about talking about the sort of the state of diversity in the legal profession right now across the country and in California in particular. And then we're going to move on from there to to look at how issues of bias can inject themselves into the hiring process and how you can recognize them and get around that. And then finally, we'll be talking about the benefits of diversity in the courtroom and in the context of mediation. Now, Judge Horn and I will be sort of handing off up and back during the course of the presentation, but I'm going to start off and then we'll go from there. So thanks very much, and let's go on to the next slide. So initially, we're going to look at the diversity in the legal profession and where we are right now. So if we can go to the next slide. All right, so let's look at race and ethnicity in the bar. So what we have in California, this is a California-specific statistic, is that white people comprise 39% of the state's adult population here in California, yet represent 66% of California's active licensed attorneys. All right, so this is a very big disparity. Now, how it got this way, there are lots and lots of different reasons, and we're not really going to get into that. We could be talking about that for hours. But basically what we need to start with is just recognizing that these are the numbers, is that white people are vastly disproportionately represented in the group of practicing lawyers in California, and the other ethnic groups are underrepresented as a result. So this is where we're starting. And recognizing that over time things have changed, and if you look at younger attorneys versus older attorneys, the numbers are quite different. But basically, if you look at the group as a whole, this is what you're looking at, where compared to the overall population in California, the attorney ranks are much wider than average. So we can go on to the next slide. So the current reality is that nationally also the representation of women and ethnic minorities in the legal profession doesn't match their representation in the general population. And if you look at it on a broad brush, the more senior or career advanced the examined attorney pool becomes, the more white and male it becomes. So let's look at some specific data when we break it down a little bit, and it'll demonstrate that progress on these numbers has been very slow. And sort of surprisingly slow, but and then we'll see where we've gone in the last couple of years. Looking at the NALP report on diversity in U.S. law firms for 2022, which is the last data we have. All right, now this slide shows basically three different things. It shows the percentage of women in law firms in 2022 as a percentage of all of these different categories, and it also shows the percentage of people of color, which is a separate Venn diagram, and then it talks about women of color, which is a subset of the other two when you combine the two together. So when you look at this and you'll notice that on the left side you have the senior most attorneys, and on the right side you have the junior most attorneys, and it sort of goes from one to the other. So basically, if you look at this, you'll see that at the partner level, women are not even at 30% of partners in law firms across the country in the United States. And when you look at minority attorneys, you're just talking about 11% at the partner level. And when you're talking about women of color, you're talking about around 3%. It's a very small number. And then when you move on to the associates, people who are more junior than that, you get more women, you get more minorities, and you get more women of color. And then counsel, which is sort of an in-between stage, generally between partners and associates, it sort of fits where you would expect it there. But what's really interesting to see is that when you talk about the non-traditional track or staff attorneys, people who are generally considered to be off-partner track, you find a giant spike in women's representation. You see that women comprise almost 60%, almost 3 out of 5, in this category of attorneys who are not on track to proceed to partner. And then you also see a larger percentage of people of color and women of color. But then when you average it all together, when you get the total lawyer number, you're looking at just short of 40% are women, even though obviously 50% in the, a bit more than 50% in the general population. Minority representation is under 20%, and women of color also under 10%, which again does not reach the total numbers. But there is a bit of a silver lining here, is if you look at summer associates, the people who are coming in out of law schools right now are not yet past the bar. The numbers are more encouraging. You actually have greater than 50% of summer associates are women. Almost 50%, a bit more than 40% are people of color, and women of color make up almost 30% here. So it's actually much more encouraging for looking down the line as to what the legal profession might look like several decades into the future, but it's not what it looks like right now. All right, let's move on. All right, And here's a graphic demonstration, which I think is very shocking, frankly. When you look at partners at law firms, you see just how large a percentage are white, as opposed to the other ethnic minorities, which all make up a small sliver. And then on the pie chart on the right shows the percentage of women and the breakdown of the different ethnic groups, and you'll see that that the numbers of women in these particular areas, for example, Latina women are under 1% at the partnership ranks, and so the numbers are very, very small. All right, let's move on to the next one, please. And then associates, you still see on these charts that whites make up almost 3/4 of the people who are here, and then the percentages of minorities of people of color are larger, and then with women it's also larger, but again it's not representative of the overall population of the United States. Let's move on one more. And then total lawyers you see, which is effectively an average of the two numbers there. You still see that the practice of law is overwhelmingly white in this country, and the percentage of women of color is still very, very small, well behind their representation in the general population. All right. Now, what's very interesting is these are law firms. These are private law firms that we were talking about before. If you look at the California state employees, the state demographics report, it's an entirely different picture. The state employees are much more representative of the general population. People who work for the state of California. You have almost a 50-50 ratio of women and men, and then you see a much more diverse distribution of ethnic identities in the pie chart on the left for people who actually work for the state. So the state has actually, in its hiring, has done much better than private law firms have across the country. All right, next one. And then another slide here, we have talking about LGBTQ lawyers at law firms and in 2022. And this is very interesting because these numbers are actually fairly substantial. It's 4.17% of all lawyers identify, remember, this is about people who self-identify as LGBTQ, 4.17% of all lawyers. And then partners are smaller, associates are larger, and summer associates, we're talking almost 10% here. Now, it's difficult to actually say how this compares with the overall population because this is a question of self-identifying. And people who self-identify at different stages in their lives, as of today, are very different. So it's difficult to tell what the actual number would be of people who are partner age in the country and in the legal practice compared to what these numbers are representing. But still, it's when people give estimates of between 5 and 10% of the population, is one basic estimate. These numbers are actually doing pretty well. All right, let's move on, and I'll hand off to Judge Horn.
Thank you, Rich. The figures for the courts are quite interesting because they don't, in the lower courts, they tend to mirror the issues that Rich has pointed out in the overall legal profession. But in our Supreme Court, the data shows that there's been either little or no evidence of any racial bias in the selection of Supreme Court justices in this state. The data shows that women have constituted a majority of our Supreme Court in most years from 2014 to 2023. The only exceptions were 2020 and 2021 when women held 43% or 3 out of the 4 seats. As for racial disparities, the data shows that white men exceeded their percent of the population in only 2 years, 2014 and 2015, and that in every other year, their percentage of the Supreme Court seats fell well below their percentage of the population. Justices of Asian descent have held either 1 or 2 seats on the Supreme Court and therefore exceeded their percentage of the population in every single year from 2014 to 2023. Justices of Black or African American descent have held 1 or 2 seats on the court, exceeding their percentage of the population in every year from 2016 to 2023. And finally, justices of Hispanic descent have held only 1 seat on the court in 7 out of the 10 years. So they have never met their percentage of the population. When we turn our focus on the courts of appeal, the data is much, much different. Women have slowly improved their percentage of seats on the courts of appeal from 30.5% in 2014 to 42% in 2023, but still far less than their percentage of the population. And of course, white men experience a corresponding decline during the same period. As for racial differences, however, white men have held more than 70% of the seats on the courts of appeals, declining from a high of 78.9% in 2014 to a low of 70% in 2023. Hispanic and Asian judges have never held a percentage of seats equal to their percentage of the population, while Black or African American justices have held a higher percentage of their percent of the population in every year except 2014. And lastly, when we focus on the trial courts, the picture is largely the same as it was in the Court of Appeals. Women have improved their percentage of seats held from 32.2% in 2014 to 39.7% in 2023, while men held a corresponding percentage of the trial court seats. This percentage still lags well behind the women's percentage of the population. As for racial disparities, white judges held 70.2% of the trial court seats in 2014, and that percentage was reduced every year until 2023, when it reached a low of 61.1%, still much higher than their percentage of the population. The judges of Black or African American descent exceeded their percent of the population in every year from 2014, 6.3% to 2023, when it reached 8.5%. Judges of Asian or Hispanic descent, however, have never reached their percentage of the population in the trial courts. And one last interesting note is in the most recent report from the Commission on Judicial Evaluations Commission, otherwise known as Jenny, which is required to report the annual breakdown of the persons in interviews for judgeships under the provisions of the Government Code Section 12011.5. The most recent data shows that there has been some progress made in recent years to address bias issues in the selection of judges. For example, of the 173 candidates evaluated by the Commission in 2022, 93 were women and 78 were men, nearly matching their respective percentages of the population. Of the candidates rated extremely well qualified, 37 or 60.7% were women, and 23, 37.7% were men. As for the racial makeup, white candidates totaled 71 or 41% of the total candidates reviewed. Hispanic candidates totaled 45 or 26% of the total, and Asian candidates totaled 17 or 15.6%. And Black candidates totaled 23 or 13.3% of the total number of candidates reviewed by the Commission. So with the exception of the Hispanic candidates, the racial groups fairly well matched their relationship, their percentages of the overall population. And then the last thing I would like to note is that before I became a judge, I worked for the California Department of Justice for 25 years. And there are some sort of encouraging figures on the makeup of the folks who are in the California Department of Justice, which is the largest law enforcement agency in the state of California, with 5,088 employees. Of those, 3,052 or 60% are women, and 2,036 or 40% are men. The racial breakdown is 43.8% are white, 19.2% Hispanic, and 22.1% Asian. Among the Deputy Attorney General classifications, there are 1,302 Deputy Attorney Generals in various classes, ranging from Deputy 1 to Deputy 5, which is a supervisory position. And of those, 53.5% were women and 46.5% were men. The racial breakdown is 46.7% are white, 9.3% are Hispanic, and 13.4% are Asian. So while Hispanics Hispanics, as in almost every other category, do not match their population percentage. And then, as Rich mentioned earlier, I don't think I'll repeat the data because Rich put up that chart, but the Department of Justice figures do not compare quite as favorably with the same figures for overall state employees, where, as Rich's chart showed, it's a much clearer and breakdown of both gender and racial makeup of the state employees as a whole, showing that there's been substantial efforts on part of the state of California to track the percentages of women and minority groups that have get hired over the years, to the point where they've been quite successful in recent years. The only other issue I wanted to talk about briefly in the bias arena was, how does it show up in the courtroom? And the answer is in several ways. The first is by behavior of the attorneys, obviously, that they're obvious, and by that I mean where there's some evidence of actual bias on a part of an attorney appearing in front of in the courts. During my 21 years, I only recall two instances where an attorney displayed one instance where the attorney displayed a clear and actual bias based on gender. And that was a male attorney who insisted on referring to his female counterpart as young lady or young woman. I warned the attorney to stop that and to please refer to his opposing counsel as opposing counsel and in a respectful tone. He ignored that order, and on two subsequent occasions, again referred to his opponent with a condescending tone of voice as a young lady. So I imposed sanctions on that attorney at that point, and his behaviors ceased. The only other experience I remember was during my years in the criminal courthouse. There were two different occasions when I found that attorneys had used bias in excluding jurors from the jury during jury selection, as required by Batson versus Kentucky at 476 U.S. 79, and People versus Wheeler, a California Supreme Court reported at 22 Cal 3rd 258. I held a hearing outside of the presence of the jurors and listened to the attorney's attempts to provide non-racial explanations for their exercise of peremptory challenges during that process. I found that neither succeeded, so I declared mistrials and restarted the jury selection in both. And in the subsequent trials, that conduct did not recur. One of the problems that's always existed under the Batson and Wheeler issues to address the jury selection bias problem is that neither the U.S. Supreme Court nor the California Supreme Court established a firm burden of proof for prosecutors to establish that their reasons for exercising peremptories were not biased against protected racial minorities. The tradition was that the prosecutors would use very standard explanations, such as the part of town that individuals lived in, or who their friends were, other personal characteristics, almost all of which were related to race in one way or another. So, but in 2020, that has changed. The California legislature enacted AB 3070, which amends section 231.7 of the Code of Civil Procedure and sets specific burdens of proof for the exercise of peremptory challenges once a Batson-Wheeler objection has been made. And the statute preserves the three-step process set forth in Batson and Wheeler. That is, the judge has to hold a hearing outside the hearing of the jury. The prosecutor must then be given an opportunity to provide non-racially based reasons for his exercise of peremptories, and then the court has to rule on the viability of those explanations. The statute requires the court to make very explicit findings. The first is that there is a substantial likelihood that an objectively reasonable person would view race, ethnicity, gender identity, sexual orientation, national origin, or religious affiliation, or perceived membership in any of those groups as a factor in the use of a peremptory challenge. And that's found in CCP section 231.7 subdivision D1. The statute goes on to impose a burden on the party exercising the peremptory to establish by clear and convincing evidence that an objectively reasonable person would view that rationale stated as unrelated to the juror's membership in a protected class. And then finally, the statute precludes use of a number of the traditional rationales used by prosecutors to justify their challenges, the ones I just mentioned, such as the location they have in people they associate, all that sort of stuff. And those categories that have been precluded now are found at 230 CCP section 231.7 subdivisions E and G. And then finally, and an important development, AB 3070 applies only to criminal cases until January 1st, 2026. At that time, it will extend to civil cases as well. So I think that pretty well covers my experience with the issues of bias as it shows up in the courtroom. So Rich, you want to take over?
All right, cool. Thank you, Judge Horn. So now that we are looking at the landscape, the question is, how can we as lawyers make progress on solving these disparities between what our country and even our profession look like and what our legal workplaces look like? And there are really three main, steps. The first thing is to basically acknowledge that this is a thing. This exists. There are disparities. If you assume that everybody across the population has a roughly equivalent desire to become a lawyer, the legal profession should be reflecting what our society looks like, and it doesn't. So the question is, we have to recognize that there must be things getting in the way of a representative bar that impacts that ability to go from desire to actual practice. And if we don't recognize that this is a thing, we won't be able to solve, whatever this thing is. The next thing from my perspective is that, when it comes to bringing people in, what we need to think about is we need to start at the beginning of someone's career, basically. And from the standpoint of practicing lawyers already, we need to look at our attorney hiring process, because when you impact the beginning of someone's career, it impacts everything else that follows from there. And the third thing, which follows from that, is that we need to search out, acknowledge, and modify points in the hiring process where gender and racial or ethnic biases might get injected into the hiring process, especially inadvertently, because nowadays most people are not out there saying, I want to have an entirely male law firm, or I want to have an entirely white law firm, or I want to have an entirely X law firm that looks like a particular thing, or I want to have an entirely whatever workplace. Most people are trying to be fair and are trying to be equitable, and don't want to actually be biased in any of their hiring decisions. But that doesn't mean that biases don't get injected even when we're trying not to. So we have to acknowledge that, how can we figure out ways that to avoid that? And I think the best way to do this, is to look at the hiring process the way a law firm might hire a new lawyer out of law school, and basically start at the beginning. And we'll start with a story, a hypothetical, a scenario, which actually isn't hypothetical. This is actually something that really did happen to me in the process of my very first time doing on-campus recruiting for my law firm. And I started as a second-year associate. So this was back in 1992, before the internet, before cell phones, before decent television in a lot of ways. And I'm going to tell you actually what happened. I was dispatched as the lawyer in charge of doing on-campus interviewing for summer associates. at a particular local law school that's very highly reputed, and we've gotten very, very good lawyers from there. And we've been interviewing there since time immemorial. And my law firm continues to interview there, I believe, my old law firm. And when you go to a law school, an employer has to abide by the rules that they set for you. And one of the big important things is a distinction is that some law schools basically say that we will send you a stack of resumes, and if you want to interview 21 people, we will send you 21 people. We, the law school, decide who you're going to interview with through our own process, and you take who we give you. And then there are other law schools that basically say, we're going to send you every resume that's dropped for you, and you can decide who you want to interview on campus. And this particular law school where I was interviewing was one of the latter, where I was basically given the opportunity by the law school placement office to choose whom we will interview. And we had put out as our guidelines that we only wanted to interview people in the top 10% of their class. That's who should drop resumes. The class had, I believe, 230 or 240 members of the entire class. So theoretically, I should have gotten 23 or 24 resumes. I got 170 resumes. All right. So I got this huge stack delivered to me in my office. And in my law firm's process, the on-campus interviewer was the person who decides who to interview on campus. So I had to take this stack of 170 resumes, and I had to choose 21 to interview on campus because I was there for 7 hours, 3 interviews per hour, 20 minutes apiece. So I basically decided I was going to read every single resume regardless of the 10% rule, and top to bottom. And I started off by setting them off into 3 piles: yes, no, and maybe. And going through the first time, the yes pile was very, very tiny, the no pile was very, very tiny, and the maybe pile was the vast majority of this. And so the exercise that took me several hours to do was to basically take the maybe pile and whittle it down to a very small yes pile. So it was, casting off people into the no pile because, 150 or so of these resumes had to go into the no pile eventually. And I would go through them over and over again, and I would whittle them down, and I would put people, aside that I'm going to decide this later, and the pile would get smaller and smaller and smaller. And eventually I ended up with 21 resumes on my yes stack. And then what I needed to do was I needed to alphabetize them to put them on a list so my secretary could actually type a list up that would then be faxed to the law school to be posted on the bulletin board, an actual bulletin board, and then people would know when they could sign up for the interviews. And so as I was alphabetizing them, I noticed something strange, that 16 of 21 people on my list were men, and mostly white men. And I started noticing this as I was alphabetizing them. And I'm thinking, because only slightly more than half of the 170 applicants were men, that I received. So I asked myself, it's like, wait a second, how did this happen? Because I wasn't looking to have 3/4 men on this list, and mostly white men. So I went back and I started thinking, what criteria were I using that might have skewed this sample where the numbers tilted so heavily in favor of men and mostly white men. And I realized that there were several ostensibly objective criteria that were doing this, and none of them were outwardly gender or race-based, which is really, really interesting because they were in fact injecting gender and race bias into my selections. And let me tell you what they were. We had a preference at the time for day program students over night program students. All right, and if you look at who goes into the day program, these are people generally who are right out of college, all the straight throughs, and night program people tend to be people who have jobs and have to keep their jobs while they're going to law school. So they spend 4 years going to law school rather than 3, and they go at night. This tends to involve more working moms. It involves people from lower socioeconomic status who can't just afford to go through another 3 years of school without having to work. And so that has a gender skew, and it also has an ethnic skew. Another thing was we had very good experience in our office with people with prior military service. And so there were a couple of people on my list who I saw that's like, oh, this is somebody who came out of the military. We had good experience with them, so that helped them get on my list. And certainly in 1992, when I was doing this, the United States military was overwhelmingly male. And so obviously the alumni of the veterans of the United States military were also overwhelmingly male. It's slightly more female now than it was, but it's still overwhelmingly male. So odds are the people who would end up on my list with military backgrounds were going to be men. The third one was just something that was just a personal preference of mine. I saw people that I liked because they went to my college, and that has a function of who's actually doing the selections. In the back of my head, somebody who goes to the same school as me, it was a decent school, and I figured, you know what, I'm going to put that person on the list just because of that. And at the time, even though it's not true now, 60% of all graduates from my college were men. So that also tilted things. And the other thing, the last one, was I put a guy on there because he was in my fraternity. As a tiebreaker, he got on the list. And of course, women are not in fraternities, they're in sororities. So as a member of a fraternity, that excludes half the population is possibly getting that benefit. And when you looked at all of these things together, it skewed, the outcome, even though none of them were saying, I want men or I want white men. So after I went back and I did it again, my list, being more cognizant of this, my list became 11 men and 10 women, which was roughly roughly comparable to the percentage represented in the stack. So next slide, please. So my lesson out of this is, in subsequent years, I started the process, when I got my stack, by taking stock of my applicant pool before I made my interview choices, so that I sort of knew what I was dealing with, so I could be cognizant of it. And then I started, and I did effectively the same thing that I did before, but in advance I knew, wait a second, this is roughly half women, or this is roughly 25% ethnic minority, people of color, or later in later years when LGBTQ people would self-identify on their resumes, issues like that. Just knowing in advance what you have makes it more obvious when you're doing something that ends up a little bit out of whack. So how do you design a process, a recruiting process, that minimizes this sort of inadvertent bias, where you're not looking to do anything that skews it, and in fact, you may even be looking not to skew it. So how do you design a process that does this? The first thing is that, you have to recognize, again, that this is a real issue. It happens even when we're not intending to be biased. And like I said, even when we're trying not to be. We also have to acknowledge that the ostensibly objective criteria we're used for screening and making hiring decisions are not as objective as we think they are. Even facially objective criteria do not always impact different groups the same way. So what do you do in this case? What you need to do is you need to go back to the first principles for what you're seeking in your recruits in the first place. Who is going to be a good lawyer? Who's going to help me in my practice? Who's going to add value to my clients? And then try to find proxies in applicants' backgrounds that implicate those factors, even if they're not what you might call traditional hiring criteria. All right. And so things like, does somebody have job experience in the subject matter area where you're working? That isn't necessarily just quality of law school and grades. It's you can look at all sorts of different things. Examples of how they've presented things in public, which might help when you're going in front of a court or going in front of a client or going in front of opposing counsel. Things that may not be just the check the box things that we have traditionally relied upon. And overall, the best thing to do really is to eliminate bright line criteria, such as nobody that isn't in the top 10% should apply. That basically, if you're more flexible and holistic in your evaluation of individual applicants and look at them as whole people, you can take into account things that wouldn't otherwise be sort of easy checkoffs that might, because of how people got there, have an inadvertent bias in it. And one thing that we need to remember is that talent is equally distributed across all groups, but opportunity is not. And so anything that impacts somebody's opportunity to get to you or to get past you and to get into your place of employment is something that doesn't necessarily impact how good they're going to be as a lawyer. So now let's go through the hiring process from start to finish to identify where you can find bias injection. Okay, let's start with, we're going to decide on the candidate pool, where are we going to interview? All right, how do we choose what law schools we're going to go to? Now, this can have a huge impact because it's kind of when the fuel that goes into the machine produces what comes out of the machine. And when we're starting at a law school, if the law school itself has a diverse group of people in it, when it comes to people of color, different sexual orientations and gender identities, men and women, and then you're just starting with that's who's in your stack, you're going to get better choices, more representative choices. For example, if you decide that when you're looking at the various law schools that you're going to include, for example, Howard University Law School, which is almost entirely Black, that's obviously going to bring more Black candidates into your pool. If you go to certain schools that just happen to be located in certain places where the population that they feed from primarily is very, very white, like a university where my nephew went, which turned out to be 90% white, just because it was a state school out of where he grew up. That just happens to be a very, very white state. If you're going to go to a place like that, you're going to get a different candidate pool to begin with. All right, so you ask yourself, is the student body sufficiently representative? And then next slide, please. Once you have your law schools, how do you choose the candidates to interview at that law school? All right, so if you're going to say, well, we want to look at academic criteria, because after all, we're trying to find smart lawyers who are going to be able to do things well, and that's a traditional way of looking at things. But a couple of things that you need to think about are, how are students graded at these law schools? For example, is it a blind grade where it's just based on your blue books at the end of the semester and the professor doesn't know who they're grading? Or is it something where the professors can include things like participation in class? Because statistically, it's been shown that that women tend to be more likely not to participate in class in law schools as much as men do for various social reasons. And that's not something we need to get into. It's just true. And so if you're including participation in grades, women tend to not do as well on those things. So the grades themselves might be gender biased. And then you also have to remember, you're only looking at first year grades generally when you're hiring for summer associates. This is everybody's first shot at taking a law school exam, which in my experience anyway is an acquired skill. And not everybody acquires these things at exactly the same rate. And so there's a certain randomness that gets into that, and it might be skewing what you're doing. All right. Other things, for example, are they on law review, moot court, or trial team, things like that? Generally, employers look well upon that because it tends to give people good experience. It gives them good writing experience. It teaches them how to stand up in front of people. It's generally a good academic credential. But the question is, who can actually has the time to do these things? All right. Because there are enormous time commitments when you're on law review, particularly if you're an editor of a law review. And if you're doing moot court competitions, trial court competitions, trial team competitions, not everybody has the time to do that. What if you have kids? What if you have a job? Not everybody has equal access to the time commitment available for this, and this might impact people differently. Job experience, are you looking at job experience, or is this something which is secondary to other things? Day versus night programs, like I said earlier, it tends to be skewed who's in the day program versus who's in the night program. And then also, who's making the choices? Like the example was that I was choosing who to pick, and I happen to be a frat guy. And so that was a benefit for somebody, and that had a skewing effect. I happen to have gone to a particular school, and that had a skewing effect for certain people. So who is actually making the decisions on these points can actually inject bias unintentionally as well. Next point is, on the next slide, what qualifies when you interview somebody as a successful or high quality interview? And so you have to think, how well do your interview criteria match the first principles for hiring and practice at your firm in the first place? Are you looking for people who can answer the question about favorite flavors of ice cream, or if you're a tree, what kind of tree you would be? Or are you looking for how well people present themselves in general on any subject that they're looking at? There are just infinite numbers of ways that you can look at interviewing criteria. But it's just a function of, are any of the things that you're actually selecting on going to have one of these unintended biases? And then very, very importantly, how much does fitting in count? You see, this is something that really is important to the success of any place of employment, is that and what I tell people, and what I used to tell people all the time when I was doing recruiting, is that when you join a law firm or a government entity, you're going to be spending more time with the people that you work with than the people you live with at home, just on hours in the day. So you darn well better like them. So actually being in a place where you feel comfortable is very important. And when you're hiring, that's also something that you have to take into account. But the danger is that you tend to just reproduce the same type of person over and over again. Who is going to be like us? Who's going to fit in with our environment, with our culture? And very often people who are not like you won't fit in quite as well, and it tends to perpetuate the same thing over and over again. So you have to be careful when you're talking about the fitting in qualification. And then finally, how are, post-interview hiring decisions made once the interview is done? Is this a committee that makes a decision, or is it individual decision makers who make a decision? For example, do you then get all of the interview reports together and a group of 5 or 6 people sit down as a hiring committee and go through everything? Or is it that, well, for the litigation position, the head of litigation makes a decision; for the corporate position, the head of corporate makes the decision; for the head of intellectual property makes a decision for an IP candidate? And if you have groups of people making these decisions, you get more information, you get more experience, and you kind of dilute whatever individual biases a single person might have when you have groups of people making these decisions, versus an individual person making a final hiring decision by him or herself brings their own baggage with them, like, as I demonstrated, and that can skew what happens. And then, that's also, a centralized hiring, hiring a class versus dispersed hiring authority for individual positions, like I described. Are you able to look at an entire class at the same time to say, well, if we're hiring 10 people and we go through the first cut and 10 of them are white or 9 of them are men, you can actually look back and say, maybe we should look at this again. Is this really representative? Are we doing, is there something that's coming in and affecting us? But if you break it up into little pieces and everybody's just looking at one thing, nobody is looking at who other people are hiring, and you could end up with these sort of odd results as you go, like I described. So, all right. Now the last thing here is that, there are long-term effects, of your hiring practices on people's careers, because, how you start people in their careers will define their career trajectory after that, because your first job leads to, progression within that job, but it also might lead to your second job or your third job or your fourth job. And as you step up through your career and you go place to place, who's going to look at you is very often impacted by where you came from before. And so your very first job, stepping onto the ladder, where you step onto the ladder can be very important. And, are you going to a place that sends feeders to the judiciary? Or is it going to send you to a place that's going to get you an in-house job? Is it going to send you to a place that's going to get you a job in the government? And so what you do at the beginning is really important to somebody's entire career in the law. And yep, so that's what we've got on that one. All right. Now, I was going to say, Katie, remind me, is this one mine or is this one Judge Horn's?
We'll be moving on shortly, but I think we're just introducing our final topic of discussion here.
Okay, right.
Here you go.
Right, okay, so all right, so there are benefits to having a diverse team that go on, and okay, so this one, you're right. This one is Judge Horn.
Thank you, Rich.
Sorry about that.
That's all right. The 3 categories we're going to focus on is first how you create your trial team and what effects can it have in the dynamics of the courtroom. And the second is the same issues for the jury selection process. The trial team issue, for example, it's oftentimes you'll see, especially on the defense side, there will be 2, oftentimes 3 attorneys on the defense side of the courtroom. There may be only 1 or 2 on the plaintiff side, except in multi-party cases. And the statistical data show, and my own experience supports this quite a bit, is that the team members are overwhelmingly all white for most of the firms that appeared in my courtroom. And that was true whether I was at the airport courthouse doing criminal trials, or in Santa Monica, where I spent the last part of my career doing civil trials. There were a number of firms that had on their teams, for example, either a woman partner or a woman, female associates on the team. But again, they were always overwhelmingly white. And when you're looking at when you're thinking about how is the jury perceiving this, and what impact it could have on the jury deliberation process, it's something that you should probably think about, because there will be the jury selection process will involve men, women, and people of diverse racial backgrounds, and the dynamics of the trial team could create some issues for you as you move through the trial process. And of course, the same thing is true in the jury selection process as well. Both of our Supreme Courts, the U.S. Supreme Court and the California Supreme Court, has made it clear that a representative jury serves a very important function in our legal system, and so the importance of having a diverse jury has led to rules like Wheeler decision and Batson case, and the process of getting that is very important. There are a couple of procedural barriers sort of built into the system at the moment. For example, the jury selection, the pool from which jury pools are selected is largely the voting rolls and the jurors who have California driver's license or other registered identification cards. And statistics show that those two groups are far less diverse in terms of race anyway than other possibilities that could be used. There have been a couple of suggestions, for example, that it might be a much more representative jury pool if we used utility bills and addresses from which to select the jurors that are actually called to serve in the courtrooms, and there are some other possibilities as well, and it's something that we think would those things ought to be considered. And the other is sort of financial wealth, for obvious reasons. People who are at the lower income scales have a harder time coming into a courtroom to serve our juries for 5, 6, 7 days and miss work as a result. And that's probably the most common excuse that you get for serving on a jury when you're a trial judge. There's a very interesting experiment that's going on up in the city and county of San Francisco. They have a program that they started in 2022, excuse me, called Be a Juror, where they have they do a little financial screening of people in their jury pools, and for those in the lower income levels, they pay $100 a day for a jury service rather than $15 a day, and the result has been a fairly dramatic increase in the diversity pool of jurors actually being chosen to serve our juries ever since they started the program. And then I think the last way these things have an impact is just on courtroom dynamics, which is, again, dealing with other counsel during the trial process, dealing with jurors during the trial process, and dealing with witnesses during the process. If you don't have men and women and people of color representing on your jury teams, there can be issues about the treatment of witnesses during the examination, and other issues, and the same thing with jury selection. So it's just a thought on how we need to think about what we're doing as we put together our trial teams and then think about the dynamics of dealing with who we are dealing with in the courtroom. So I think that about covers it, Rich.
Yep. And so the last point is, in the context of mediation, as Judge Horn mentioned, there are obvious, benefits to having a diverse team in a courtroom, but also in mediation, having, being cognizant of issues like this and having the availability of a deeper bench. And I don't mean bench in the court sense, but bench in the baseball sense. Can really be very helpful when you're trying to resolve a dispute through mediation. Because remember, resolving a dispute is partially rational and partially emotional. Some people are just mad, and people are angry, and they're wrapped up in the case, and both needs have to be addressed to be successful. And having a team that understands their clients and the opposing clients helps to build the credibility, the connection, and the trust necessary to a successful negotiation. And a lot of times, having different types of people, in your bullpen, depending on who your clients are, who opposing parties are, and where they come from, can be very helpful in sort of establishing all of that. And because part of the understanding, credibility, connection, and trust often derives from common experiences or backgrounds or frames of reference. And it's about relating, as human beings when you're in a mediation. As much as a lot of times people are just, think of them as the enemy, but that's really a lot of times what goes on. And so having, people from different backgrounds on your team will allow you to put the right people in the room to get the benefits of that understanding and connection with a wider range of clients and opposing parties. So it's certainly one of those areas where at a minimum it's, can't hurt, might help. But just from a psychological standpoint and from a human relations standpoint, it's actually quite a benefit. So that's the end of our presentation, and we have Hayward. Do we have a minute to take a question, or should we just punt and keep running?
If you have any closing remarks, I think perhaps we can end the presentation on some closing remarks.
Okay. Judge Horn, you want to go?
I just want to I thank the staff at ADR, in particular, my trial team, Ella Fishman and Jesse Lee, for all the work they've done and helped me with this presentation, and for all the other things they do for me over the time. And thank the management of ADR for giving me this opportunity to participate in this program.
Yeah, I'd like to reinforce that as well, and also just to let people know that this isn't about trying to check some sort of box. This isn't about trying to achieve something that you can put on an ALP form. This is about trying to make your own firms and your own place of employment a better place and a more effective place. And this is about getting as much talent as you possibly can from as many different places as you can into your shops, so that they can help you, that you can help your clients better. So it's something that helps us all if we focus on it. And thanks very much for listening.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.